Oh, great.
Yes.
Here we go. You ready?
Thank you.
All right, it is 8:36 and call the meeting to order. First roll call by district. Who's here for District 1? One. District 2.
Jeff McCune. Angel Garcia, alternate.
And I'm here for District 3. Jenny, are you on the phone? How about District 4? And District 5?
Ralph Rons is attending.
Right, thank you. We have a quorum, so I'm going to go ahead and consider the first action item, which is the approval of the agenda for today's meeting. Has everyone had a chance to take a look at it?
Yes.
Yes.
Is there a motion to approve?
So moved.
Sorry?
So moved.
Seconded. I'll second.
Yeah, we can get to that even. Okay, sure. Okay. Actually, Veronica pointed out to me that we might want to amend it slightly. Number 6 in our list of items states as an action item, subcommittee recommendations. That's carried over from last meeting. In fact, we also have number 7, which is an action item, which is actually approval, modification, and or issuance of advisory opinion. Those are the same advisory opinions. So will you agree to an amendment to the agenda to remove the action item status of number 6?
So moved.
All right, second.
Well, I actually need to look at them at the agenda specifically. I don't have it right in front of me. If it's the advice of Veronica and we're not taking something off the agenda, then I'll second again. But I
Same,
need the agenda.
same document number for both.
Okay.
Yeah. All right. Well, I think we have a motion and a second. All in favor
Aye.
of the agenda as amended?
Aye.
Any opposed? Motion carries. Item 4 is approval of the February 13th minutes. We had tabled this. Let me think about this. So we've got the same issue this time in that we don't have 2 board members, or 3 quorum of board members who were involved at that meeting. And so I would accept a motion to table that again, approval of the February 13, 2023 minutes. Is there a motion?
So moved.
Second.
I'll second.
All in favor?
Aye.
Aye. Motion carries. So the action item 4, approval of the February 13, 2023 minutes will be tabled until the next meeting. Number 5 is approval of the April 20, 2023 minutes. Has everyone had a chance to review the minutes of our April 20th meeting?
Yes.
Yes.
Do I have a motion to approve those minutes?
So moved.
Second,
Second.
all in favor?
Aye.
Aye. Motion carries. The April 2023 minutes are approved. Item 7, since we have amended the agenda, is approval, modification, and or issuance of advisory opinion. I guess it's 2023-001. Has everyone had a chance to open and review the draft advisory opinion 2023-001 that was circulated by Ms. Gonzalez Zamora?
Yes.
Yes.
Right. That reflects recommendations by the subcommittee appointed to consider the advisory opinion. Is there, I guess I'll ask if there's a motion at this time.
Are we gonna have a discussion about this
I hope
issue?
so.
Yeah, we can start with discussion. Yep.
because it does include, it says modification, and if we were going to have any modification, we should have discussion first. So.
All right. Is there, would anyone like to kick off the discussion?
Well, as you know from our last meeting, I have concerns about our limitations regarding state and federal law and corporations being considered persons. And I think that if we need to have modifications in law that allows the commission to do a better job of screening potential violations of contribution law. I have a strong visceral reaction to influence peddling in our politics. We have, we had a council person having bullets shot at their house, and this kind of opens the door to this permission to act out. I've seen it in international disaster relief where there's gray markets all the time and black markets and influence peddling at the highest levels in disaster relief, and it creates a situation for actions and violence and inappropriate contributions and you name it. And so when someone gives $1,000 in one donation, and there's a limit of 1,000 for a restricted donor, and then another 1,500 shows up, or, and then totaling 4,000, even on the same day that a application to the commission for IRBs or LEDA grants is happening, we're not stupid. And it's obvious that there's a situation that we need to be cognizant of, especially when you see $1,000 from one donor, and then everyone else is $100, $150, $50. It's obvious that there's a potential for even appearances of influence peddling, which is not good for the county. But if we don't have laws to support what this board does at the state and federal level, we'll end up with another lawsuit like the Year Out lawsuit, and we can't enforce what's going on here. I reached the subject that if we could have some regulation where a donor that could be potentially viewed as a restricted donor would waive rights to subpoena financials, we could, just follow the money and see what's going on between a person who might benefit from a contribution, even though that contribution is a personal one. It still is in favor of the corporate entity that is going to get all these funds. I mean, $4,000 for a $9 million program, and there's several of them. What a bargain.
And these are things we talked about in the subcommittee. Let me just suggest this actually pertains pretty closely to number 8, talking about the proposed amendments, which I think is going to be important discussion. Ralph, did you have any comments about the actual draft opinion that the subcommittee put together?
I do. Now, I only read through it once, and after I had read through it once, I thought, I think I should read through it again. It is really well compiled, and I thank you, for all involved in doing this. The first comment I want to make is that it appears to me that Commissioners Baca and Olivas were good on them to bring this to the attention of this Code of Conduct Review Board. I would say well in advance of anything being submitted as a concern. Now, having said that, one thing that was, and I jotted it down, it was on, I think, the bottom of page 3 of the advisory opinion, in which it states if this person is seeking to do business with the county or something before the county commission. And I had trouble with the decision, and maybe that's what, is it Chuck, right? That was.
Yes. Yeah.
Okay.
Chuck.
If we don't have the wherewithal with the existing language to make a determination on some kind of explicit definition of what a restricted donor is, then I would agree with that. I mean, this has every appearance that Mr. Long knew what he was doing. You know, he's an original founder of this Heritage Resorts. If I, you know, I don't have, I didn't print out anything and I don't have it right now in front of me.
And he's a CEO. He's a CEO too, we think, of that organization, although he does not identify as that.
Right. It just has every appearance of, you know, the language that Chuck used of now it's escaping me. I didn't take notes on that, but it just has every appearance
influence peddling.
Of influence peddling.
Yeah.
He made those donations to, you know, Commissioner Baca was, you know, very much favored to win her seat. It would be interesting to find out if in the primary, Mr. Long also made a contribution to the candidacy of the incumbent. And then if Mr. Long made similarly a contribution to the opponent of Commissioner-elect Olivas during the general. And I don't know if we can go beyond that, but it just, and then the fact that it was at $1,000, it's as if Mr. Long knew what the limit was and didn't exceed that, but went right up to the limit, whereas he had exceeded that limit in the primary, perhaps knowing that there is not an issue there if he gives it to both candidates, if we can find that out. I just think this would be an opportunity for us to, I guess you could say, draw a line in the sand. I mean, I appreciate everything, all the thorough investigation that went on in writing this advisory opinion. It just still strikes me that it's quite apparent that Mr. Long knows exactly what he's doing with these contributions, and that if you were to draw some type of a flow diagram that would indicate, you know, the members of that, you know, Heritage Resorts and all these people, I think you could follow the money. I think Chuck also used that word. So that's my take on it in reading it through once. I hope I just made sense.
Thanks. I think you did. And a lot of that is information that the subcommittee was obviously talking about, Chuck being a member of it. I guess my question would be, is there some wording of the code under which you think we could reach a different result?
Now, is that going on to the next agenda item?
Well, it's not. And so obviously, I think all of us are eager to talk about ways we can fix the places where the code does not address what we hope it would address, isn't specific enough to really prevent conduct we think is improper. So that is the next agenda item. And I would like to appoint a subcommittee, which I think you indicated you would be willing to serve on, to talk about that. But I think just as a matter of procedure, we have the code we have right now. And under our analysis, we couldn't reach a decision. I think the opinion contains information indicating our concerns in several places. And that leads to some obvious discussion about what parts of the code we need to take a hard look at. But just as a procedural matter at this point, we've got the code we've got, and we have the facts that we have. And I guess the question is whether there's any suggestion that there needs to be any different result, any modification or amendment of the draft advisor opinion.
Well, you know, I'm new to the review board, and that may be a lame excuse. And I haven't thoroughly digested, you know, every element of what what we operate under right now. But my read of what I saw in the advisory opinion, and please, no insult intended, maybe because of the advice of Veronica, as you were going through this, you arrived at a conclusion that said that Mr. Long is not a restricted donor. It just seems to me, in everything that was captured in that advisory opinion, I was still a bit maybe, I don't know, confused is not the right word, but I still don't understand how you couldn't arrive at the conclusion that there was every appearance that, given the long history of Mr. Long in the real estate industry, and in full knowledge of that he has done business before the county, even if he is not directly involved in some type of submission, it just struck me that why wouldn't he be identified as a restricted donor?
Would it be helpful to go over the definition that we have currently in the code and try to find anything that might be read differently?
You know, as we look at that, I think the code is pretty specific about anyone who would gain by something before the board for decision. And he certainly is in a position to gain. And if we were, and I think that we would be allowed to do this at the county level, to make a requirement that even a suspected restricted donor, if a council person is to take a donation from someone like that, who obviously has an appearance of conflict in terms, or potentially be considered a restricted donor, or passing money through from a restricted donor, that they waive the rights to object to a subpoena of their financial records. I think we could do that. And that would not go fly in the face of the corporate entity issue as being decided as a person. And I think Veronica's opinion on the advisory is about the fact that what was evident in the year out case, that we don't have the rights to oppose this kind of conduct under the law,
Under the current code.
under the current
Right.
law and the code and the law, because a corporate entity is different from Mr. Long.
Yeah, just to bring back up, the last donation of $1,000, correct me if I'm wrong, Veronica, but would even from a restricted donor have been permissible? That's the dollar limit.
That's right.
Because it's up to and including $1,000.
Exactly. But the kinds of things that we can talk about in the next agenda item and in reforming the code would be, do you cumulatively want to add all of the donations that you've done for the primary and the general, so that can't be, aggregated and come up to a bigger sum? Currently, there's nothing to prevent that, to prevent you from doing it.
If you were limited to $1,000 to any commissioner in totals, that would split it up between the commissioners.
That's
I
another,
think we can do that.
that's another possible amendment.
And then there's not as much influence. I mean, is he going to buy a $9 million IRB with $300 to one? And I mean, it's just less influential.
Right.
And it also would deal with the issue of appearances.
I have another question, is that
Yeah.
there was something, and I don't have a printer at home, and I didn't print this out, so I would have to be, going off to another screen here to look at this. But isn't there some part of this advisory opinion that was stated something to the effect of, like almost that this is non-binding? We reserve the right to come back to this in the future if something were to come up that was more apparent. That was one thing that caught my attention, if I've remembered that correctly. And then I would, and maybe it has no bearing on this, but the idea that Mr. Long, or would it have bearing on this decision if we were to find out that Mr. Long made similar contributions right up to the limit to the other candidates running for county commission? be they the opponents in the general to Commissioners Baca and Olivas, and maybe even in the primary. And then the idea that Chuck raised is like when you look at or maybe it was you, Martha, raised the idea of considering the aggregate of all the contributions that were made that would exceed that $1,000 limit. And again, I hope I've made sense in my points.
I think so. To take the second one first, and I'll let Veronica correct me if I'm wrong. I think that contributing to every single candidate in the primary and every single candidate in the general at the levels that Mr. Long did would not allow us to do anything differently under the code that we've got right now.
Okay.
So, and as to the first, if I'm understanding your question, I mean, this is limited, this opinion in terms of both what it addresses and what benefit it provides, if any, to our commissioners, to the facts that we have. So obviously those facts about other contributions, I think would clearly not make a difference. If there's something else that you're thinking about, then by its language, this isn't intended to be any broader than it has to be. It is supposed to be limited to what we know. And I think the opinion mentions that.
And then one other comment, and is that, is there any way in which, now this advisory opinion as it's written, is this something that would be conveyed in total, to Commissioners Baca and Olivas?
I believe it would be.
Yes.
Yeah. I mean, it's a response to a request that they made, and under the provisions of the code and the regulations, they can do that. They have the ability to do that. And so that's the purpose of it. I want to make sure that we hear anything that Rocky may have to add.
No, I think we're relying on the Johnson versus Mays case in this particular instance. And, relying on that particular judgment, if I will, I think this board is kind of guided on what a person's rights are for making, because contributions are political speech. I mean, that was the decision. And this gentleman being separated from his entities, I believe that's the guidance of the board, and that's the decision the board went with in this particular decision. I'll admit, I think there are some good points on clarification for definition 2 of a restricted donor, right? Does business or seeks to do business, because that is in the capacity of a person, not a business. But at the time, the donation, we have to consider the contract and the donation, the origin of the donation. It came from the business. And according to Johnson, it's appropriate for the person separate from that business to make a donation. They have a right to do that. So I get it. There is some ins and outs for this particular decision, but, I'm glad it was clarified as well that Commissioner Baca was included. And forgive me that I saw that, but I thought maybe because the advisory opinion was directed for Commissioner Olivas, that she could rely on it because she was under the same conditions. But I'm very glad that that was included for her as well. And I think you had a lot of wisdom in, my comment was that your recommendation provided a defense. I think it was also a defense for the perception of any wrongdoing in the past of Commissioner Olivas and Commissioner Baca, where, they weren't aware of his status as a restricted donor. That was an important fact before their term. And so I don't have any problems at this point with the advisory opinion myself. I think it was very thought out. And I do understand there's questions regarding the interpretation of the code and the decision from Johnson. But relying on Johnson, I believe this opinion is.
Thank you for raising that. You know, when we were struggling with this, it was the Johnson opinion that was very frustrating to us because it is the inclination of, I think I can speak for Chuck, I know of me, when we're trying to reason through this, not to allow there to be what Chuck has referred to as influence peddling or any kind of appearance of that. And so obviously the board back in, was it 2018, struggled with the same problem. They came up with the result that, you know, maybe we all wish we could come up with under the code. And that is that they found a violation in the year out case.
Yeah.
It went to court. And so the board was schooled by the district judge about the fact that the code talks about the original source of a contribution. It doesn't talk about, it doesn't allow inferences that are not based on substantial evidence that actually an individual is contributing on behalf of a corporation, as much as it might be clear or seem clear to everybody that that's what's going on. So having a court decision that told us we analyzed things incorrectly under our code last time, that was a big factor in what we came up with, and agreed, unsatisfactory, I think, to everybody, the old board that was considering this, and sounds like all of us here. Do you have anything you wanted to add?
Well, I just wanted to state that it kind of seems right now that you know, that the conclusion you guys came to, it's, I mean, Mr. Long knows how to play the game, and he did that. But for future amendments, like you guys were talking about, yeah, we could progress with that. But as far as this goes, like the year out case right here, it factually states that the owners and the corporations are two different entities, and we've seen that with Citizens United, where the corporate entity was granted religious freedom. So I agree with what you guys came up with here, and I think coming up with measures to prevent future things like this. But as far as this one goes, I think our hands are tied.
You know, I think in light of it's Rick, right?
Rocky,
I'm sorry. In light of what Rocky said, we can chip away at this too. We can, for example, I looked at some of the donations and it just has Mr. Long as CEO. CEO of what? I mean, we can make red flag kinds of requirements that someone identify themselves CEO of what? And that way the commissioners taking the donations would have some accountability for the knowledge that they have that this person is connected with heritage. I mean, it would be a really good paper trail for us to just even start with that. And then when the light is shining on these folks, they'll be less inclined to conduct themselves this way. The more light we shine on what they're doing, the better.
Yeah. Agree.
I'll just quickly weigh in, is that, I mean, I appreciate the comments just made by in the order, Martha, Rocky, Angel, and Chuck. I mean, all of this stuff is really helpful, I think, as we go forward on the next, agenda item. I'm fully understanding the limitations that have been placed on this review board by the existing language, and I now have a full appreciation of how you came to your conclusions in there. I'm not crazy about them because I think I definitely see the thread of how, what you had to go between, and thanks Veronica for your help on this. I think I fully understand now just how you had to interpret these things so that once again, we could be in alignment with what maybe a future court would find.
And also, by avoiding court cases and litigation, we save Glendale County money. I mean, it's just, these things cost money for staff to deal with these things. The litigation takes a long time, and the constant participation in this sort of methodology should be avoided if we can.
Yeah, where it's foreseeable that we're going to run into the same problem that a court's already looked at, it makes it kind of exercise in futility, it seemed to us.
Right. And again, I have to go back and look at the advisory opinion again to remember actually what you were trying to say at the end. But is there a way to convey to Commissioners Baca and Olivas, I guess you could say our appreciation for them bringing this matter to our attention, and also that it has helped us find out that since we are limited in how we might regard these donations coming from a restricted donor, that we are going to be looking at refinements or amendments. Or maybe that doesn't even have to be said. Maybe that's just something that we keep under our hat, but we're going to pursue that.
Veronica, you want to address
Yeah.
that?
Yeah, Ralph, we actually talked about that as a subcommittee, and we ultimately decided that because this opinion becomes part of the record for the Code of Conduct Review Board, right, that we're sort of like binding ourselves to actually make an amendment, but we don't have that power. We can only suggest, recommend things to the county commission. So we thought it would be better just to say, based on what we have, we have to rule this way, right? We being the royal we, you all. But that then we would have this other opportunity to create another subcommittee to then talk about that more formally and then formalize any suggestions to the county commission.
Okay.
But yeah, all that is to say, I don't think it needs to go in this opinion. I'm happy to add it if you think it's important to put there.
No, it's, thank you for the answer. No, I understand.
I think we should use the year out judgment as guidance for chipping away at all this, and everything we propose change should be without flying in the face of that judgment, without challenging that authority. And like I say, I think we can do incremental actions that just shine a light on what's going on. And if we keep that in mind, we won't end up in court again over these things.
Yep.
Just keep chipping away at it in little ways that are within our purview.
Or maybe don't chip.
Yeah.
Maybe do a bigger.
Well,
overhaul.
Overhaul.
as an activist, I'm fine about going bigger, but
Yeah, if the law changes, the code of conduct changes, then the year out Johnson opinion is no longer good law, right? It's no longer good precedent because the
Right.
law has changed. So there's that option too.
okay,
Right?
yeah.
Yeah. Okay, well, we really teed up the next item, but before we talk any further about possible changes to the code, I want to make sure we make some action. This is this draft opinion. Is there any other discussion before I ask for motions?
May I make one comment?
Yes, of course.
I saw in one of the footnotes that it's mentioned that there might be a conflict between the code itself and the rules and regs. In reading it, I don't see a conflict. I think the rules and regs actually match what the code requires, and I can pull that up here real quick. So, I mean, it's not a substantial thing, but just for purposes of the decisions itself. I'm looking at,
I think it's footnote 1.
yeah. And for advisory opinions, review board, it does say that it shall be a complete defense when any complaint where a candidate or public servant asks for the review board for an advisory opinion prior to taking any action prohibited by this division. So I think it refers to future actions there. And then the language itself that was referred to, it's kind of general language. So I don't think the rules and regs actually conflicted with it. The rules and regs just said this is the step we're taking moving forward, which is actually number 2 under, excuse me, I'll give you the exact here. 13.2-133 H. So J2. So just a little comment on that. I mean, I don't think it's substantive for this particular opinion. Just for future, I don't think they conflict.
So Veronica, remind me if I'm remembering right, we were looking at, I think the part of the regulations that 2014 regulations that talk about advisory opinion requirements, that's subsection C. And subsection 3 under that says the request shall be only about prospective conduct or application of the ordinance, not past or present actions. And maybe, obviously we are only talking about prospective or future actions. And so maybe in that sense, there's not a conflict. Our concern, I think, was to make clear that we were not addressing something that was outside of the purview of what we're allowed to do in these advisory opinions, which is to try to advise for future things, not to try to justify any past conduct. Is that fair?
Yes.
Yeah.
Mhm.
Well,
Do you think there needs to be any change are you suggesting a change to the opinion?
No, like I said, I don't think it's a substantial issue. I just wanted to, I think just for reference. I can't see the conflict, because
Mhm.
word is here. I believe there appears to be a conflict, to have a slight conflict in allowing only request about prospective conduct. And I think that's what the ordinance actually says. So just for reference, but I don't think it's necessary to change at this point.
Okay.
something I think needs to be said, or it's always in my mind when I look at this sort of conduct, is that, we work for the people. Yeah, at this table, we work for the people. And this sort of conduct disenfranchises those who don't have the means to do this. It's marginalized communities, people in poverty, people who don't have the influence capability. And so it's up to us to stand up for them.
Good point, Chuck. I have another question, is there a timeline that we are under to issue an advisory opinion based on this request from Commissioners Baca and Olivas? And the reason I ask that is, we have a couple members of this review board who could not attend today, one of them being brand new to the board. It's my thought that if we don't have a timeline on this, we don't have anything pending before the review board in which we are supposed to be taking an action. Could we kick this down the road, and I say this in a positive way, that would allow the two other members of this review board to weigh in officially at a next meeting, if at all possible, and give their thoughts on this, so that they're not bound by the decisions of the three members of us, even though we do meet a quorum.
Rocky or Veronica, do you know what the next action or deadline decision-making process there is on these applications?
I had to defer to Ms.
Yeah, I don't know. What I do know is that there's a sort of like a final vote, and the two commissioners were waiting for this board to opine about the applicability of the code before allowing that agenda item to proceed. So they're sort of waiting on us. I mean, in our rules and regs and in the code of conduct, we don't have a deadline like we do with other types of matters where we have to decide them in so many days. But I think this original request came in maybe March. And so it's already been a couple of months, in case that's helpful to your decision.
So is this holding up the funding?
Yes. Well, assuming it gets approved, right? I mean, it's.
That's sanctioned right there.
Okay, so let's see. There is supposed to be the county commission, they decide what their agenda items are going to be. And this is a pending decision before the county commission about this particular IRB. And if we waited another 2 months, then we, in a way, are imposing on them to wait another couple months.
Exactly.
Oh, boy. Oh, boy.
Yeah, and I would add that, of course, Bob, I think he was going to come to the meeting and then had to bow out, but he obviously had the draft opinion sent to him. Who knows if he had a chance to read it. Mr. Jeffries is, I guess, according to his message in Greece. So we haven't heard, but we don't have any assurance that we would hear in any particular future meeting from either.
I think it's a good idea to get all the opinions if we can. We do have a quorum, but it's better to have unanimity about our actions.
Procedurally, how would that look?
I was just thinking that, so procedurally, any action on the advisory opinion has to be in an open meeting. So I wouldn't be able to sort of like collect the feedback and then allow you to make a decision later. We'd have to do all of that via open meeting. What I would suggest instead is maybe to invite them to join the subcommittee, right? To sort of break down this opinion a little more about what we think the next steps are. And they can give feedback on that. And that's a little easier. Subcommittees don't have to meet in open meetings. You can meet in they don't even have to announce their meetings because it's not a quorum. It's only 2 members.
I at least am around for a couple of weeks and then I'm gone for a couple of weeks after that. So I don't know what your schedule is, Chuck. And we of course don't know. I don't know when Mr. Jeffrey's returning, and I don't know what Bob's schedule might be in the next couple of weeks. But from my standpoint, I'm not going to be able to be involved until then, after June 18th. So
June till when? June 18th?
Yeah, I'm leaving at the end of the month and then I'll be gone through June 18th. So, if we could somehow make it available to everybody, even if they can't actually attend for another couple weeks, that would work for me. Actually, not even 2 weeks.
Would they even have to join the subcommittee? Sometimes people don't want to join any more committees. Could they even just visit with the committee?
Yeah, I think they wouldn't be technically joining the subcommittee. They would join a meeting of the subcommittee, is what Veronica said.
In an advisory kind of capacity to give us input on what we're recommending.
Attend the way anybody.
Yeah, that would work.
Member could.
I'm similarly gone. Would not be able to attend any meetings, even via Teams, from June 2nd through June 28th. I'm going to be out of the country. But I agree with Chuck. I think it'd be good to have unanimity on this. And I mean, this really, I think, is a big deal. It really is. And again, I thank Commissioners Baca and Olivas for being forthcoming on this, for us to be able to give this advisory, investigate and give this advisory opinion. So I think it's a good message to send that we want to have the other 2 members of this review board weigh in.
So let's just think this through. If we were able to schedule a meeting of the subcommittee for attendance or not by the other 2 folks in the next couple of weeks, we still would need another meeting of the board to be able to vote.
Yes.
Okay, so we're talking about fitting 2 things in before May 28th.
So you might as well schedule 1 meeting and just talk about it as a group, right? Do the notice.
Yeah, I guess that's right. We wouldn't, yeah.
Available with a week or 2 notice on a meeting.
Okay, well, given that, is there any obstacle to our setting another meeting of the board in terms of notice and all of whatever the requirements are for setting it up? And then deferring this agenda item, this action item, until that meeting, schedule-wise? Is that, Chuck, you can be available?
I just don't know the dates. Of course, I'm not in front of my calendar, but
right.
I think that's reasonable. An advisory committee meeting first and then a board meeting?
Well, as Veronica is pointing out, we probably wouldn't need to have a separate advisory committee meeting, but we would have all of this discussion in session, in our public meeting where that rescheduled a vote on this. Rocky, have you got some thoughts?
Yes, ma'am. Thank you. I don't know if it's important to your decision-making, the request for Local Economic Development Act, the LEDA Act, that they're requesting. The company is expected to start construction July 1st.
Ah, okay.
So just that was their request, and
Is that
finishing here and then getting it before the commission.
Right.
But if that's, I mean, this is important, what you all are doing.
Does that open
Maybe
us
might
up
want to be aware.
to any kind of litigation?
Well, there's a subject I'm not going to weigh in on.
I'll have to get back to
Yeah,
you.
it's gonna have an effect on them if they can't get the money.
Let me do this, I guess, just so we can kind of see where we ought to go. Recognizing that all of us would prefer to have a unanimous vote, recognizing there's some logistics involved in getting that. Let me just ask if there is a motion to approve this advisory opinion as it is. And if there's a motion and a second, well, then we don't need to do this. If there's not a motion and a second, I guess then we'll have to look at other options.
Okay, I really appreciate all of this discussion on this, and I think maybe it can be reflected in our minutes that the other two members of the review board can read to see how we struggled, or maybe not struggled, but really tried to consider everything, and that maybe we would go ahead and just act on this agenda item today, given all this, and then just count on our two other members to read this and understand it, and then hopefully weigh in on agenda item 7. So with all that, I'll make a motion that we approve this advisory opinion.
Is there a second?
I would second that with the understanding that we're going to be continually working on this issue and potentially revise it again in terms of what we come up with in the subcommittee and with the input from the other members.
Revise the opinion again, because I'm not sure we have the opportunity to do that.
Well, I don't mean revise the opinion. I mean revise our recommendations later to figure out how we better deal with this in a more well-considered way. So I would second this motion.
Okay.
Do this.
All right. Any other discussion? All in favor?
Aye.
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 Opposed? Motion carries. All right. Well, we've really teed up number 8. Let me, I think we've aired this pretty well. Obviously, in the course of going through this, the subcommittee recognized the fact that not only did we feel like we needed to talk about amendments, we talked about this at the last meeting, I think, but also it was clear that the 2018 board struggled as well. And in fact, when I looked back at the opinion in the Gear Out Johnson case, it mentioned that there were some apparent amendments drafted to address this kind of conduit issue, I assume, in the code. We can't really figure out what those were, and they were never, as far as we can tell, presented to the board. So this is a long-standing problem that really does need to get addressed. I think we all agree. It's pretty clear from all the comments here today. So with that, what I would like to do is appoint a subcommittee to address changes to the code. And my understanding, and again, Veronica, I'm looking to you to tell me if this is correct, is that a subcommittee of this 5-member board can only have 2 members?
Correct.
Okay. Ralph indicated he would be willing to serve on that. I also spoke with Jenny Lusk, who is actually my alternate, and she indicated she has time and would be very interested in a project that would revise the code to address what we've been talking about here today, but also, whatever else we all agree needs to get looked at. And I think, go ahead.
Excuse me for a second, but I just saw an email. I went to see about my other attachments, and there was an email from Jenny Lusk, now that you've mentioned her name, at 8:58 a.m. saying she was in the team's waiting room.
Oh, no. And is she not here? Jenny, you're not on the.
It would show.
Why don't I give her a ring and fill her in?
Okay, yeah.
Sure.
But what I'd like to do is try to identify as many things as, we had a lot of great ideas today. Identify some of the things that we would like them to focus on. And that doesn't need to be exhaustive. I mean, any member of the board can talk to the subcommittee, I think, Veronica.
It's a little shaky because under Open Meetings Act, if you have a quorum, you have to give notice.
So
So
2 members
three
of the
at a time.
subcommittee.
Yes.
Gotcha. Okay.
We did correct.
Can they attend meetings with, of the subcommittee with council, or is that not feasible?
I'll have to look at the Open Meetings Act again, to double check. Because maybe I can check in individually and share that information with the subcommittee.
Okay.
As opposed to all 3 or 4 meeting at once. I'm also wondering about the alternates. Maybe they can
Mhm.
participate because they're not voting members. So I'll look into that and I'll let you know.
Okay.
Yeah.
Yeah. I mean, what I don't want what we talk about here today to be the only things that we are asking the subcommittee to talk about revising. So whether it needs to be a wholesale revision of every single provision of the code, probably not, but I think it would be helpful to surface what we can today and give them kind of a mandate and then recognizing that there may be some other good ideas that come up later.
I'm for ripping off the Band-Aid and digging out the infection.
Okay, what does that mean?
No, when you said give them a mandate, maybe give them direction or give them advice. And them is the members of the subcommittee that were, and possibly me being a part of that subcommittee. Again, I will be gone June 2nd through the 28th. So if that has any bearing on what kind of action that we would expect to happen, it would have to be delayed until at least July for me. Unless we were going to start talking, between now and June 2nd.
Well, I think that would be probably up to the subcommittee members. And
Okay.
I mean, in appointing subcommittee, I don't think we necessarily give them a deadline. And obviously, we have a state code, and Veronica's pointed out that it addresses many of these areas we've talked about with regard to the individual versus entity status. And so I think it's helpful that there is something that is more robust than what we have that we can look at. Not that we would agree with every single part of that, but I think it's really expedites the work, I'm hoping. So we're not starting out from ground zero. But so we've talked about the restricted donor, let's see, just to kind of make a list, I guess, if it's helpful as guidance. We've talked about the cumulative nature of the donations. We've talked about
Chuck mentioned identifying yourself if you're just the CEO of what entity?
Right.
The relationships.
So the disclosures.
Yeah,
Mhm.
disclosures.
and I guess that may or may not be the subject of a code. I mean, I'm mindful that some of this is kind of operational in nature. We can mandate what we need to mandate in the code, but the details of what kind of forms get filled out at what point in time seem to me also an issue for the compliance office. But I say that not really knowing. I'm making it up. But I agree. We need to know CEO of what, and however we need to make that happen.
Mhm. And if there's some way that we can follow the money from source to donation, some requirement in disclosure, some requirement for the donor to, how much they stand to financially gain when something before the county commission gets approved. What's the salary of this guy? I mean, is he asking for $9 million and $8 million goes to him? I mean, we don't know anything about this money trail.
Yeah. I imagine we'd get quite a lot of pushback on that, but.
I bet we would.
Okay, how about subsection M, where they talk about public financing? Is that another area that we need to kind of look at? That is section 2130, what it is, which currently talks about, excuse me, the business that contracts with the county for financial services, but it really doesn't address the individual contribution. Just while I'm totting things up, I guess another area that came up is the conflict of interest and whether it is specific enough in terms of what the benefit would be to a public official. What monetary benefit does that include of political contribution? It's pretty vague right now under the code. So I'll throw that in there. Yeah.
Another, and maybe this is not covered in the existing rules and regs on this, and I don't have those in front of me, but both Commissioners Baca and Olivas received those donations during the primary, or at least I remember that's what was applicable to Commissioner Olivas, is that do we make it incumbent on candidates for elected office to know what these rules are, you know, in terms of restricted donors and campaign contribution limits from restricted donors, so that when they are accepting things, they don't just say, oh, wow, look at this chunk of money that fell out of the sky for my campaign. Wow, that's great. And not ask any questions. Am I clear in what I'm trying to say there?
Yes, I understand, and I agree.
Long, knows how to, as Angel said, play the game. But these candidates, they're busy trying to run their campaign, and they're happy to have this infusion of money into their campaign. But I think it's still important for them to know about when they sign up for this. They've got to know about restricted donors, and they have to know about campaign influence. They have to know about limits. So that would be another factor that would perhaps go into our consideration as we might rewrite this.
So not being able to take a contribution without acknowledging the code, like a checkbox on terms and conditions on any, I mean, they would have to legally acknowledge that they read the terms.
And that's something we really kind of dealt with when we had our case and the situation involving the former commissioner and the restricted donor situation. So I agree.
And what about what Chuck mentioned earlier too on contribution caps? Because he donated to both District 1 and District 5, obviously where his interests are. What if he could only donate to one or the other, or split it?
I think if we dilute it, it's better.
Yeah.
If it's $1,000 for everybody on the commission, that would be a very significant change. And I think we're within the law to do that.
Yeah, I mean, again, we'll hear what the commissioners think of all these things after we come up with our perfect code.
Well, Angel mentioned Citizen United. This is an endemic problem.
Mm-hmm.
We're dealing with the fall of empire here. We don't do something about it. We're complicit.
Yeah.
Yes.
Thank you, Madam.
Or we're not maybe helping to move the needle because there's so many other things going on like this across the country. I mean, of course, we're all probably noticing what has gone on in the Supreme Court with Justice Thomas and the influence peddling that went on there for years. So that's right in the courts, not even a candidate for elected office, but someone that can never be touched again by any kind of an election. But anyhow, wow, this has been great.
All due respect to Anita Hill.
Who deserves it.
Yeah.
Our compliance officer had a comment.
So there's been comment that there's confusion, especially for candidates, not so much being aware of the code, but relying on state statute that limits contributions of sorts for campaigns at $5,000. So some folks are saying, well, we're relying on the state, it's different. And then they come to the code and they're noticing the contrast, right? We're limiting it at 1,000. So I'm not sure for your consideration if the issue is the amount or the fact that restricted donors are, limited to a certain amount. It, just for consideration, it might also eliminate any problems to match the state. That way, when somebody gives a donation and, it's in accordance with state law as well, even restricted donors are limited to the same amount.
So is a restricted donor, is a contributor limited to $5,000 in total for a primary or general, or are they limited to that amount for a particular candidate?
Honestly, I would have to research that.
Okay.
Per calendar year.
Per calendar year, okay.
Yes. So if
So-
there's more than one election, you have to sort of plan it out.
I see. And our code limits 1,000 per primary.
Per any, right? So primary, general, special. So you could donate 3,000
Okay.
theoretically.
Yeah, I appreciate that because if it has come up and been an issue and someone has suggested that it's difficult to live under both of them, I think it's fair to take a look at that. I mean, these amounts are, quite honestly, they're a lot for your average citizen in Albuquerque. And so that would be our concern. But on the other hand, in the scheme of the money we're talking about for projects, they're not. So
in context of what Rocky just said, there's a defense right there for anybody going right up to $5,000.
Possibly.
And relying on the state code, has the authority to do so.
Regardless if you're a restricted donor or not,
Yeah.
that's the cap. And then it reduces any question of the limits and who's a restricted donor, who's not.
And that looks like another potential lawsuit right there.
Yeah, and I would just say to make some of these changes and restrict certain individuals from allowing to be made contributions, that could be contested, right? Just say, hey, you are, not affording me my rights as an individual to make contributions. So we need to be careful with language and how it's entered, limiting folks based on the Johnson when they divided the individual from the business, and they're saying you're limiting me on my right to contribute.
my First Amendment right.
Right to free speech. So just some things.
So do we recommend to the commissioners that they lobby the legislature to allow for a county entity to make its own regulations about its own elections?
I guess everything is on the table.
If they put that, even that simple clause in there, we'd be allowed to limit it to $1,000.
And it may already have that authority, truthfully. I'll have to check for you.
Okay.
What I'm hearing is that it sounds like it's more important for us to address the issue of how we define a restricted donor than it is the dollar amount. At least that's what's occurring to me right now. It's the idea of what constitutes a restricted donor.
Yeah.
This is a discussion item, not an action item. And so I don't, I want to make sure we have whatever discussion we all have while we're here, especially among the board members and our alternate and the compliance officer. Veronica, do you know if there's any, I guess we still don't have Jenny, if there's any reason why the subcommittee couldn't include an alternate? She is my alternate.
I haven't seen anything saying that they
Okay.
cannot.
Yeah, I can't
participate
imagine
because
why
they're not
not.
voting members.
Yeah.
So I want to double check the quorum notice requirement under Open Meetings Act, but certainly our code and the rules and regulations wouldn't prohibit it.
Okay. Well, that's my intention, and it's not an action item, but I have spoken with Ralph, as I understand it, you are willing to serve on a subcommittee that would be charged with reviewing possible amendments to the code.
Yes.
That fair? Okay. And recognizing your time limitations. I spoke with Jenny Lusk, my alternate, and she's willing to serve and has time to spend and really dig in on this. And so with that, I'm going to go ahead and appoint a subcommittee to do that. However, if there's more discussion, today here about things that we should have them consider, I'm all for it.
The subcommittee of of Chuck and Martha, I can address you by your first names, right? I don't have to say
Yes.
Mr.
Fine.
McHugh and Ms. Brown.
That's fine.
Okay, great. You met with Veronica, sometimes virtually, sometimes in person, and that's all to be worked out later.
Yeah, we actually didn't meet in person at all.
No.
I think we had one Zoom call and then the rest of our discussions were primarily by email.
Which are privileged discussions.
Mhm.
Okay. Well, then I commend you again for what you guys came up with. Thank you.
So Veronica would be participating in that, in the new subcommittee. That's good, because
Yes.
if I were on that committee, I wouldn't do it without her.
Thank you.
Yeah, I mean, there's no way that I could come up with the way that was compiled, by myself, or not knowing Jenny, but between the two of us, boy, we'd be hard pressed to come up with that. So thanks.
Yeah, having had the experience we just had, we really appreciate it.
Thank you.
Our professor. So, all right, any other discussion about the subject of amendments, proposed amendments, which, by the way, as we all know, just to reiterate, however, the process is the subcommittee would come up with a draft, I assume, for consideration by this board. This board would review it, agree, not agree, make changes. And from there, it would go on to the commission. The commission will do whatever it sees fit to do with it. If we get that far, which I earnestly plan that we will. So.
Okay.
Okay. Mr. Kleinfox, or any other?
No, thank you. Appreciate it.
Okay, yeah, thanks.
Thank you.
All right. I would entertain a motion to adjourn at this point.
So moved. I have a question. I had on my calendar a meeting for the 30th. Maybe it's a placeholder.
Came out, yeah.
Okay. It wasn't from your invitations. It was just, I put a note there. So thank you.
Mhm.
So I moved.
Should we plan, Martha, to regroup at some point, maybe end of this?
I guess I missed our action item on scheduling the next meeting. I would entertain a motion to have Rachel proceed the same way she normally does to investigate the availability of everyone and set our meeting. Is there a motion?
I moved, so moved.
Second.
And that is not until the month of July, or is that just investigating open-ended?
Ordinarily, it would be August, I think, because it'd be quarterly. Yeah. And at this point, we haven't identified the need for any other meeting of this board before then. So yes. Is there a second?
I second.
All right. All in favor, say aye.
Aye.
Motion
Aye.
carries. All right, and Veronica, you were gonna suggest meeting
Oh, maybe July time,
to talk about,
whatever the subcommittee comes up with.
oh, so having another meeting before August.
Or August, it could wait till August. There's no
you're-
rush, but
Pretty optimistic about about making headway.
well, and I'm wondering, are there any elections coming up this year? Like, is this something we want to be in place before the next big thing? I don't know.
I
Wait, wait,
don't
you
follow
are.
till I see the ads on TV.
I know, right? I haven't gotten anything in the mail. Yeah. So there's time. We
Now,
can-
there are
Is that-
city council elections in, but I'm not sure about which commissioners might be up for, which commissioner districts are open. Is it not until next year?
I'm gonna defer
That's a good
to
question. I don't know.
I don't know.
staff member on that.
I'm thinking that if Commissioners Baca and Olivas were elected just last year in 2022, the next ones won't be up for election until 2024. So we don't have something immediate to be considering in terms of primary or general until 2024.
So that's great.
I'm trying to answer Veronica's question there.
Thank
Yeah,
you.
no, I think that's
Okay.
So that being the case, it doesn't seem we need to try to shoehorn in a meeting before August.
Right.
All right. Any other business? Okay, is there a motion to adjourn?
So moved.
Second,
Do I say
please
now?
second a
all in
motion to
favor?
adjourn.
Oh, I thought you were seconding, Martha. Martha.
Oops. We've lost you. Can you hear us?
Blink once for yes.
I can hear
Put up
you.
the 2 for second.
I'm not sure he can hear us.
If there's a chat.
Maybe we should put up a note.
Yeah, give him a second.
Mel, can you hear us? Nod if you can hear us. Do you second the motion? There we go.
Second.
Oh, okay. All right. All right. All in favor?
So on the record.
Motion carried. We're adjourned and it is 9:47.
8, yeah.
8. Yeah.
Thank you all.